Good evening, Dr. Emma Izzati. Our group would like to present an insurance case about Cheng Poon QV Berjaya Shampoo Insurance Berhad. And our group members are Kimberly Kong Miu Ling, Liu Carroll, Ko Su Hua, Chao Li Yan, and Hao Wen Chong.
Hello, good morning everyone. My name is Wen Chong. Today I would like to presenting a landmark federal court case in Malaysia. That is Cheng Poon Ki vs Berjaya Shampoo Insurance Berhad. This case is important because it deals with a third-party rights under motor insurance and clarify how the Road Transportation Act protects accident victims, especially those injured while traveling for work. For the case background, Cheng Poon Ki was the injured in a motor vehicle accident while traveling as a part of his job. He successfully sued the vehicle's driver and owner and won a judgment in court. However, the insurance company Berjaya Shampoo refused to pay, arguing that Chen was excluded from coverage because he was a passenger under a contract of employment, as stated in the Section 91, 1B BB of the Road Transport Act 1987. The High Court and Court of Appeal agreed with the insurer, but the case was then brought to the Federal Court for the final decision.
Good morning everyone, my name is Ko Su Hua. I will present party involved in this insurance case. Cheng Poon Ki is a parent. Cheng Poon Ki is an individual who was injured in a motor vehicle accident while traveling as a passenger in a car owned by his wife. He sought to enforce the judgment directly against the insurer Berjaya Shampoo Insurance Berhad. Berjaya Shampoo Insurance Berhad is respondent. Berjaya Shampoo Insurance Berhad is a licensed insurance company in Malaysia. It provides various types of insurance coverage including motor, property, personal accident, and travel.
Good morning everyone, my name is Kimberly. I now present the court findings in the case of Cheng Poon Ki vs Berjaya Shampoo Insurance Berhad. First, the Federal Court found that the plaintiff, Cheng Poon Ki, qualified as a third party under Section 96, subsection 1 of the Road Transport Act. Although he was in a vehicle under a contract of employment, this does not exclude him from protection. Therefore, the insurer, which is Berjaya Shampoo Insurance, cannot use Section 91, subsection 1, paragraph B, subparagraph BB to avoid paying the claim. Secondly, the court ruled that the third party Cheng Poon Ki does not need to file a separate lawsuit against the insurer. When he wins a judgment against the insured, Berjaya Shampoo Insurance is automatically required to pay under Section 96, subsection 1. This simplifies the process for victims and ensures quicker access to compensation. Lastly, the court clarified that if an insurer wants to avoid liability, it must act early. The insurer has two options. 1. It must apply for a court declaration under Section 96, subsection 3 before judgment is given. Or 2. It must intervene in the original case. If the insurer does neither, it becomes legally bound to pay the judgment amount.
High Court decision involving Berjaya Shampoo Insurance Berhad, which carries significant implication for insurance law and third-party claims under the Road Transport Act 1987. In this case, the High Court ruled in favor of Berjaya Shampoo Insurance Berhad. The central issue revolved around the interpretation of Section 96, subsection 1 of the Road Transport Act 1987. The court clarified that under this section, a third-party claimant is not automatically entitled to recover judgment sums from the insurer. Instead, the claimants must first initiate a separate legal actions, a recovery proceeding against the insurers. Only after this process is complete does the obligation arise for the insurers to satisfy any judgment obtained against the insured. As a result of this finding, the High Court granted a stay of executions on the judgment originally issued by the enforcement of the judgment is paused until the appellant properly filed the required recovery actions. This decision reinforced the procedural safeguard insurers are entitled to under the law and highlights the importance for third-party claimants to adhere to the proper legal role when seeking enforcement against an insurer. Continuing from the High Court decision, I would now like to present the outcome of the appeals in the case involving Berjaya Sompo Insurance Berhad. The matter was brought before the Court of Appeal, where the appellant sought to challenge the High Court ruling. However, the Court of Appeal dismissed the appeal and affirmed the decision of the High Court. The appellate court reiterated the legal requirement under Section 96, Subsection 1 of the Road Transport Act 1987 that a third-party claimant must file a separate recovery proceeding against the insurers before any enforcement of a judgment obtained against the insured can take place. The court emphasized that allowing enforcement without such a recovery action would deny the insurers a fair opportunity to raise any legitimate defenses, and in doing so could compromise the integrity of the legal process. This decision further cements the legal positions that insurers are not automatically liable to satisfy third-party judgment, and it underscores the importance of following proper procedures to balance the rights of all parties involved. In a significant turn, the Federal Court allowed the appeal, thereby setting aside the decision of both the High Court and the Court of Appeal. The court delivered a clear and impactful interpretation of Section 96, Subsection 1 of the Road Transport Act 1987 RTA. It held that a third-party victim is not required to initiate separate recovery proceeding against the insurers in order to enforce a judgment obtained against the insurer. Instead, if an insurer wishes to contest its liability, it must either obtain a declaration under Section 96, Subsection 3 before liability is established or formally intervenes the original tort suit. This approach ensures that any objections from the insurer are raised promptly and within the appropriate forum. The Federal Court also emphasized the underlying purpose of the statutory third-party insurance scheme, which is to ensure swift and efficient compensation to road accident victims, minimizing procedural hurdles and avoiding unnecessary litigation delays. This landmark ruling realigns the interpretation of the RTA with its original intention to protect victims and streamline access to justice.
Rationale. First, statutory purpose. The Road Transport Act 1987 establishes a statutory scheme to ensure quick and guaranteed compensation to third-party victims of motor vehicle accidents, minimizing procedural delay and excessive litigation. Second is direct liability of insurer without separate recovery action. Insurer must pay the third-party judgment under Section 96(1) of the Road Transport Act without requiring the victim to file a separate recovery lawsuit. This prevents unnecessary delay and extra litigation costs. Third, Section 91(1)(b)(bb). Exception does not exclude employment-related passengers. Passengers traveling under a contract of employment are still protected as third party under the Act, so the insurer cannot exclude liability on this ground alone. Last, insurer right to challenge. Insurer can challenge its liability either by obtaining a good declaration under Section 96(3) that the policy is void before the liability arises, or by intervening in the tort suit to raise coverage defenses timely.
My name is Charlie, and today I would like to present the lesson learned in the case of the Chambonki versus Berjaya Sompo Insurance Berhad. First, we learned that the clarification of insurer liability. The Federal Court clarified that under Section 96(1) of the Act, once a judgment is entered against the insurer is directly liable to the third-party victims. This removed the need for victims to sue the insurer separately, simplifying compensation and speeding up payments. Secondly, we learned that the importance of employment context. The court also emphasized that passengers traveling under a contract of employment are covered by the Act Section 91(1)(b)(bb), regardless of whether they work for the vehicle owner or the third party. These broad interpretations prevent unfair denial of claims based on narrow employment definitions. Thirdly, we learned the insurer obligation to act promptly. The ruling highlights that insurer must act promptly before judgment. If they fail to intervene or seek a declaration under Section 96(3), they become automatically liable. This stressed the importance of timely legal actions to avoid financial consequences. Lastly, we learned the impact on financial institutions. From a financial and risk management view, the case shows that insurance company and financial institutions must understand and comply with their legal duties. Failure to do so increases risk, financial loss, and reputation harm. It demonstrates the close link between law, risk management, and compliance in the financial industry. In conclusion, in the case of the Chambon-Quy vs. Berjaya Sompo Insurance Berhad had highlights third-party rights under the Road Transport Act 1987, allowing victims to claim directly from the insurers. It stresses insurer accountability, timely policy enforcement, and legal compliance. From a financial perspective, this case highlights the need to understand statutory obligations and ensure a clear compliance policy terms. It also emphasizes timely actions to manage risk and uphold public trust in insurance services. Thank you for listening. This is all of our presentation in the case of the Chambon-Quy vs. Berjaya Sompo Insurance Berhad. Bye bye!